State versus Ian Leisman, 20 CR 165.
Yes, sir.
Okay, you're in court. Let me see what we got here. It's a motion to revoke probation has been filed in this case. You have the right to have an attorney represent you in this matter. If you can't afford to hire an attorney, I'll appoint one. Do you know what you're trying to do with regard to an attorney?
No attorney, sir.
Alrighty. Somebody give him a waiver form then.
But
You have the right to hire your own attorney. Like I said, if you can't afford to hire one will be appointed, no cost up front to you. If you choose to represent yourself, you have to follow the rules of evidence and procedure just as if you're an attorney. There's no special treatment. Are you going to influence any alcohol or drugs right now?
no, sir.
Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. If you've reviewed the form and want to waive it and proceed today, representing yourself, you can sign it at this time.
This isn't a dramatic jury trial. There's no shocking evidence revealed, no surprise witness. This is something much more common, and in many ways much more dangerous, a probation violation hearing. The defendant, Diane Lehman, isn't here fighting new charges. He's here because the court believes he violated the terms of probation, the very agreement that kept him out of jail in the first place. And here's the critical detail. He has chosen to represent himself. Because probation hearings move fast, judges expect preparation. They expect accountability. And when someone walks in without an attorney, especially in a case involving mispayments and a court-ordered drug and alcohol evaluation, the margin for error becomes razor thin.
You've signed it. I'll find that you've knowingly, willingly waived your right to an attorney. I'll accept that waiver. I'll allow you to represent yourself. You understand you have the right to contest the allegations. Do you have a copy of the allegations, by the way?
No, sir. On the probation violation?
Yeah.
I believe it was for the remaining payment of the probation, because that was
Right. Also failed to provide proof of obtaining drug and alcohol evaluation. Those were the allegations.
on to do which one?
We'll bring you.
The drug and alcohol evaluation?
Yes.
Okay. Alrighty. I did not do that unless I had done it with and sent it to Chris before, but yes, sir.
All right. Well, we're going to bring you a copy of those allegations here. All right. You understand? You have a copy of those in front of you, the affidavit alleging the violations?
No, it was the wrong paper. He's grabbing it right now. But I understand, sir. I do believe that I had forgotten the last time I talked with Chris, I do believe he had said that, and I had forgot about it and just thought it was payment.
The judge has confirmed the waiver. That means Mr. Lehman is now fully responsible for navigating criminal procedure on his own. No objections coached by counsel. No strategic framing. No legal buffering. And here's why that matters. Probation violation hearings may sound informal, but they carry serious consequences. The burden of proof is lower than a criminal trial. The judge has broad discretion. And admissions, even casual ones, can seal the outcome. Notice how thorough the judge is. He's covering every right. That's not just formality. That's protection for the record. Because once someone knowingly waives counsel, appellate courts rarely show sympathy later.
Let me go over your rights with you. You have a right to contest the allegations that you violated probation at a hearing in an open court. It's the state's burden to establish a violation by a preponderance of the evidence. You have the right to present testimony of witnesses and other evidence on your behalf if you want to. If a probation violation is established or admitted to by you, I can continue, extend, modify, or revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, sir.
Do you understand all your rights as I've explained them?
Yes, sir.
All right. It's alleged that you failed to make payments as required on your court costs, fines, as ordered by the court, and that your last payment was back on November 5th of 2021, and now you have still have a balance of $418 to that allegation. Do you admit or deny?
That I paid that up in full. Whenever I paid that, I believe it was this last week or the week before. and then scheduled for the court date for today.
Is it paid up?
The prior, I had made made arrangements. My mom had come over and to the court and paid everything remaining because I had moved down to South Texas, and then but they had added more charges, and then but the drug evaluation part, that I had forgotten all about that. But I mean, there's no record of like I have not been in trouble or.
When a defendant casually acknowledges he forgot about the drug and alcohol evaluation, that's not just an oversight. That's an admission tied directly to a court order. In probation world, forgetting isn't neutral. It's non-compliance. And listen carefully to how the judge approaches it. Calm, measured, giving space. That's intentional. Judges often allow defendants room to explain themselves, but explanations must show responsibility. Instead, we're hearing partial acknowledgement mixed with uncertainty. I think, I believe, I forgot. That language weakens credibility.
It's paid off.
Well, and originally she had come up here to pay him. She paid everything they had on file, and then they had added that last $418 after she had come here to pay.
So the balance is $418 still. Is that correct?
No, that was paid last week or the week before.
Let me just go look.
We don't know.
We have no way of looking now. Well, let's skip that because
She said if it went to collections and he paid collections, we haven't been able to get it from them.
it may have went to collections. Let's just skip over to the next one. It's alleged you failed to provide proof of obtaining a drug and alcohol evaluation as ordered by the court. To that allegation, do you admit or deny?
I admit I did not do that.
Okay. I'll find that you, Mr. Marcinski, right now, the court has no way of checking into any of this. I think it's been sent to collections is what I'm being told. So they don't know what's been paid, what hasn't been paid.
And if he has a receipt.
Yeah. Okay. Are you fine with skipping over the payment, Mr. Marcinski, at this point?
Well,
I'm not going to have a way of making a finding on it one way or another anyway, Miss, what I'm telling you. Nobody knows.
it appears to me that he is stipulating as of the date of this affidavit, he had not paid it. So the fact that he paid it 2 days ago or a week ago doesn't alleviate the fact that he committed this violation.
Well,
So
that's okay.
I'm not going to contest that he hasn't paid as of today, but it would seem to me that as of the time of this PV affidavit, that amount was
It's all academic. I don't put people in jail for not paying their fines usually anyway. So
An outright admission to failing to complete a court-ordered drug and alcohol evaluation removes the state's burden. The judge no longer needs evidence. The violation is established by the defendant's own words. Now, notice something important. The judge isn't eager to jail him over unpaid fines. In fact, he explicitly says that's not typically how he operates. That shows discretion. That shows restraint. When probation includes an evaluation, it's usually because substance issues were connected to the original offense. Ignoring that requirement tells the court the underlying issue hasn't been addressed.
to the second violation, I'll take the first one under advisement until stuff can be sorted out. I'm just not going to get into that right now. It's not really necessary. State's recommendation.
Judge, I may defer to Chris on this one. Looking at my file, we're a little light. All I see in here, my last notes in this file were when I offered Mr. Leesman a plea from the felonies that Kerwin had charged him with to a misdemeanor. The very next thing I have is the PV affidavit, and then my most recent document in the file shows a no bond warrant for his arrest. So obviously that at some point was lifted because he's bonded out and sitting in front of us.
I don't think so. I think he had us put on the docket and showed up. I think the warrant's still outstanding is what I'm told,
Or
Okay.
like so.
as far as we know.
So I would probably ask Chris what he thinks is appropriate at this point. If the case is paid in full, my primary cause for doing what I do is to try to get these folks into drug and alcohol treatment to help them get over their addictions. And it sounds like even as of today, that hasn't occurred in this particular case. And I see now that 3 years, almost 4 years later, I don't know what the benefit of that is, but there has to be some consequence to the violation. I mean, pretty much just disregarding of the probation. So I think at this point, Your Honor, I would probably request a sanction and then for the case to be terminated if it has indeed been paid in full, which I'm not.
When both the prosecutor and the probation officer recommend revocation, the temperature in the room changes instantly. Those recommendations carry weight because they reflect supervision history, misreporting, lack of follow-through, and in this case, even telling the officer to just file the affidavit. Probation officers document everything. Sporadic call-ins, missed deadlines, lack of initiative. And when those details are laid out in open court, they shape the judge's perception of effort to this moment. The focus is no longer on forgotten evaluation. It's on a pattern of disregard.
Contesting based on his statement that it has been paid. I would also ask the court to maybe ask Chris Hollis what he thinks is appropriate, at least as far as the sanction, and he may be able to even educate us about the payments and other things.
Your Honor, Mr. Leisman was on probation for almost a year, and he was on call-in reporting because he was a resident of Texas. Last time I spoke with him was on February 8th of 2022. And I informed him that he needed to come to Kansas so he can sign an extension of his probation due to the fact that he had not completed his drug and alcohol evaluation. And he didn't make, well, he still had an outstanding balance of $418. He told me that he's not going to make the time to come to Kansas, and that if I need to file an affidavit, then just go ahead and do it. And then, of course, we haven't heard from him in over a year. Almost 2 years. So my recommendation is that his probation is revoked.
All right, Mr.
And
Lee.
when he did call in, Your Honor,
Okay.
it was very sporadic. He would miss call in reporting. I'd have to call him, try and track him down. So he wasn't even really good at even that. So.
And unfortunately, the explanation never quite lands. Instead of clearly outlining steps taken, future plans, or concrete efforts to comply, the response drifts into circumstances, an accident, travel difficulties, logistical concerns. Now, those may be real. But in court, mitigation needs structure. Judges look for three things: acknowledgement, responsibility, and a concrete corrective plan. And remember, this violation stretches back years. The longer a condition goes unfulfilled, the harder it becomes to justify. When someone represents themselves, they often speak from emotion, but judges decide from record and pattern.
I do apologize for getting of that. I'd gotten in another accident right around that time before. It was October when it was October before that February. I had talked to him, so I'd been healing up, and I forgotten about that drug and alcohol evaluation. And whenever we had talked, I had asked, he said I had to be here tomorrow to sign the paper. And I was asking, because I couldn't come from Port Aransas at that time all the way to Kansas to sign a paper. And I was seeing if we could do it like over like fax or, over like e-documents. So I didn't have to come in person all the way to Kansas to extend it for me to go do that drug and alcohol evaluation. But I do apologize for forgetting about that part. And I could get one done as like today, as soon as we leave here. I just wanted to get this warrant taken care of, but I understand.
Notice how brief the ruling is. No anger, no lecture, just a firm decision. That's often how experienced judges operate. Measured, efficient, final. The reasoning was clear: deterrence and accountability. The judge even framed it as a message to others about following probation orders. What makes this moment difficult is a shift in tone from the defendant. Suddenly, the reality of 6 months hits. The questions change. How long? Is there any with probation was the alternative to jail? And when its terms weren't followed, the fallback option activates automatically.
Well, at this point, I want you to become a productive member of society. I think the only way you can do that right now is that you become sort of deterrence and encouragement for other people to follow the orders of probation. So I'm going to revoke and remand you to serve your sentence. Good luck.
Wait, sir, how long is it? I came up here I came up from Texas all right, sir. All right. How long do I have to do?
Whatever the original sentence was. I think we went over that, didn't we?
The original sentence was 6 months. I don't know if he's got any credit for time served on that.
Yeah, that's what it is, 6 months.
Or it was for a misdemeanor. I still have to do 6 months.
Yes, sir.
All right, sir. Okay. Is there or no? My bad. Is there any way to like that?
It's
Never mind.
it's time to face the consequences. That's what's happening.
What-
State versus Colton Marceau, 23 CR 300025.
Yes, can you grab my phone right there?
Sure.
Mr. Lehman originally avoided 6 months in jail by accepting probation. But probation isn't passive freedom. It's structured accountability, missed evaluations, unresolved payments, sporadic reporting, and ultimately, an admission on the record. The judge wasn't harsh for the sake of it. He was consistent. The violation was admitted. The supervision history showed minimal compliance. And without strong legal advocacy or documented mitigation, the court exercises authority. The biggest takeaway? Representing yourself in criminal court is almost always a gamble, especially when your freedom is on the line.